Well, hello once more, and thank you for joining me. My name is Lior Samfiru. You see that below me? I know it's a mouthful, but that's okay. I'm the employment lawyer, and I am here as I am every week to answer your questions, to hopefully give you some peace of mind if you are facing a workplace problem. I'm one of the founding partners of Samfiru Tumarkin LLP. We have a large firm that helps employees across Canada, in Ontario, in BC, and in Alberta. So if you have a legal issue surrounding your job, surrounding your employer, boy, have you come to the right place. This is the session for you. I am here at your service, so to speak, answering your questions live. You have an opportunity right now to type in that question, hit return, and I'll see it and I'll answer it. And you can take that information and knowledge with you. I don't care what the issue is. Maybe you've lost your job. Maybe you're worried about losing your job. Maybe your employer is mistreating you. Maybe there's a new policy that your employer put together and you want to know if it's legal, if they can do that, and what can you do about it. Whatever the issue or the problem, this is the opportunity live right here on this session to ask your questions. Ask as many as possible, and I'll give you the answers. Now, every single week when I'm here, people always rush to ask questions towards the end of the session, and then I run out of time and you may not get your session answered. Don't do that. If you have a question, ask it now. There's a lot of time. I can see it, I can read it, and then you can ask a second or third follow-up question even because we have time. So take advantage of me being here for you, and I'll answer your questions. Now, let me give you some other contact information before we get started. If you want to connect with me and my team, have a large team off social media, easy to do. All you do is you grab your smartphone, your tablet, your desktop, whatever your device is, and you go to employmentlawyer.ca. Again, it's employmentlawyer.ca. You see that address below me. That's my website, my firm's website. When you go there, you can read a lot about your employment law rights, but you can also get phone numbers there, email addresses there. You can connect with me, send me an email, give me a call. It's all there at employmentlawyer.ca. So the first step, you want to ask a question, you ask it right now, easy, I'll answer it. Second step, to get going, to get me to help you and roll up my sleeves and get to work to enforce your legal rights, all you do is you go to employmentlawyer.ca. I'm going to start answering some questions right now. If you're watching me, don't be bashful. Ask your question. Again, my name is Lior Samfiru. I'm the employment lawyer, and I'm going to do what I do now, which is answer questions about employment law. First question today from Luco on YouTube. Non-union employee, leave of absence since November due to refuse to get the jab for religious reasons. Was approved for EI benefits. If I ask my employer to pay severance, can they refuse to pay severance because I'm getting EI benefits? Well, I can guarantee you that if you ask your employer to pay severance, they won't pay it. There's no chance of them paying that. I need to ask them. In fact, I need to make them. You asking them is not going to do anything. They're going to say, no, we haven't let you go. We just put you on a leave of absence. That leave of absence, in the eyes of the law, is a termination of your employment, and you can get severance, but we need to get involved on your behalf. Every single day, we're resolving matters that have to do with these leave of absence, with vaccines, every day. So give us a call. Let's get to work. Now, to your question about EI, yes, EI could impact the value of your case, but you still have entitlements, you still have rights, so that really should not impact your situation in any way. If you're on a leave of absence because of the vaccine status, or you've been let go, let's talk about it. Your employer is not just going to pay you severance. I guarantee you that. We need to get involved on your behalf. And again, for Luco and anyone else to connect with me off air, to get me working for you, easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. Thanks for that question, Luco. I'm going to continue answering questions. Next question from Karma on YouTube. I'm a city employee, contract, 3-year unionized, did not comply with vaccine mandate policies, testing, and I'm on an unpaid leave of absence since November. Am I entitled to severance? Okay, so first of all, if you're a unionized employee, only the union can help you. And a unionized employee doesn't get severance. You could get your job back, you could get back pay if you haven't been paid, but you don't get severance in that situation. So, but anything and everything that I talk about on these sessions only applies to non-union employees. If you're a unionized employee, there's only one thing I can ever tell you, and that is you have to talk to your union. They're the only one that can advise you and represent you if needed. I can't help you. No employment lawyer can help you. It has to be the union. If you're a non-union employee, man, oh man, this session is for you. You can learn about your rights quite a lot, and I can help you enforce those rights. So thank you for that question. I'm going to continue answering questions. More are coming. So again, see how easy it is, guys. Ask your question. I know you're watching, which is great, but ask your question. Next question on YouTube from Sir G. Could you briefly speak to your fee structure, in particular, if there's a difference between a settled claim versus going to court claim? So every case is different. Most of our cases are on a contingency basis. In other words, we take a percentage of anything extra we're able to get for our clients. That percentage usually is anywhere from 30 to 33%. Sometimes it's lower. And one of the things we do in every case is we negotiate compensation for legal fees over and above the other amounts. Okay, so we negotiate compensation for legal fees over and above that, so that some of the legal fees at least are not going to come from you, they're going to come from your former employer. But the reality is that if it matters on contingency, you don't have to worry about funding this, you don't take any risk. Now, in some cases, we're not able to offer contingency, but most cases are on contingency, and we can assess that only when we speak, when we do a proper consultation. So when you do a consultation, the person you're speaking with, whether it's myself, one of my partners, or colleagues, they'll be able to tell you, here are the options. And sometimes we may give you more than one option. But listen, we understand that most of our clients are people that just lost their jobs or in a difficult financial situation. So we do everything that we can to help in that situation. So thank you for that question, Sir G. And I think it's an important one. Next question, again, comes from Rocket. I was given a written warning for violating company policy. I wrote back to them why I disagree with it. They haven't written me back. How long do they have to respond until it's accepted? They don't have to respond at all. In fact, I'm happy with them not responding. My concern is that you don't agree with it if it's not right. So by you saying, I don't agree with it, and here's why, you've protected yourself. You're going to make it much more difficult for the company to let you go. You don't need them to respond. In fact, their response is the same as them saying, I agree. Whether they respond or not, irrelevant. It's important that you did the right thing. You said that you disagree with it. If you were just silent, then that could have been interpreted as you accepting that and agreeing with it, and that would have made it easier for the company to let you go for cause down the road. So you've done the right thing. If there's any problems, Rocket, connect with me, easy, employmentlawyer.ca, but you did the right thing. For those joining me, hey, welcome. Thank you for coming and joining and spending some time with me today. My name is Lior Samfiru. I'm the employment lawyer. You can find me, my team, at employmentlawyer.ca. And the reason why I'm here, as you can see, is to answer your questions. No hidden agenda, just to answer your questions, give you some information, and make sure that you feel better about your workplace rights. So we have some really good employment laws in Canada, across all provinces. A lot of people don't know what those laws are. They don't appreciate how good they are and how much they're protected with these laws. That's why I do these sessions, to make sure that you're informed and you're educated. And I want you to spread the word, okay? Others should know about their rights as well. Again, to connect with me, easy, employmentlawyer.ca. But right now, I am live. You are live. So ask your questions. Take advantage. You still have plenty of time to do that. Okay, let's see. Next question today comes from Anita on Facebook. I am on maternity leave, and my position has been eliminated. When I go back in December, they don't have a plan for me when I return. What does the law require them to give me in terms of a position upon my return? My employer has indicated that I would need to apply for a different job internally, but I don't see how it's my responsibility to find myself a new job. You're right, it's not your responsibility. Their responsibility is to find you another job, if there is one, as long as it's something that's similar. If there isn't a job, legitimately, they've tried, they've looked, they've eliminated that position, it just doesn't exist anymore, and it has nothing at all to do with your maternity leave, then they can let you go with full severance. But I'd be very concerned if all of a sudden the position just doesn't exist. You want to ask yourself, did they give it to someone else? Did they spread the duties amongst other people, or did they simply shut down the department? If they shut down the department where you work, well, there's nothing you can do. But if your job is being done just by other people, that potentially is a human rights violation. That's potentially an employment standards violation. It's illegal. Now, and you're right, you don't have to apply for another job. It's their responsibility. They have to give you your job. If they don't meet that responsibility, let me know. If they've already told you that they're not going to meet that responsibility, we may be able to do something right now about it. Okay? If it's still in limbo, then we'll deal with it in December when you're ready to come back to work. At that point, again, they have to take you back. If they don't, I need to talk to you. I need to talk to you right away. Okay? So Anita, easy to connect with me. Just go to employmentlawyer.ca. Happy to chat with you, whether it's now or in December. Thanks for that question. All right. Next question today comes from Archie on YouTube. Can my employer let me go if I am on a medical leave? I have seen that my job has been posted by my employer. Well, here's the thing. Your employer, if you're off work, your employer is allowed to run its business. What I mean is if you're doing a job and they need someone to do the job because you're off, so the job has to be done, they're allowed to hire someone else because they need the job done, right? That doesn't mean that you're fired. All that means is when you're ready to come back to work, they have to try to find a position for you. That doesn't mean that they have to fire that person, okay? That would apply in a maternity leave. They may have to fire the new person. But in a medical leave, they don't have to fire the person. They just have to try to find you either the same job if it's possible or similar job if it's possible. If at that point there isn't a job available for you, then they can pay you severance. But we deal with it when you're ready to come back to work. So right now, I wouldn't even worry about it at all. Right now, focus on your health, focus on getting better and getting ready to come back to work, whether it's going to be another week or a month or a year, that's fine. And when you're ready to come back to work, let them know. At that point, if they say there's no job, that's when we need to talk. I want to make sure that what they're doing is legitimate. And of course, I want to make sure that you're paid the compensation that you're owed. But remember, for now, if they're hiring a replacement, unless you're gone for a very, very short period of time, they are allowed to have someone do that job because presumably it's a job that needs to be done. Archie, if you have any concerns or follow-up questions, ask now. Happy to answer them. By the way, again, for those joining me, my name is Lior Samfiru. I'm the employment lawyer. I'm one of the founding partners with Samfiru, Tumarkin LLP. Maybe you've seen me on TV or heard me on radio. I host the employment law show across Canada, another opportunity for me to advise and educate people on employment law rights. But right now, right here on Facebook, on YouTube, I am live answering your questions. So ask them and I will continue answering. Luco has a follow-up. Luco says, thanks for answering the first part of my question, but can my employer refuse to pay severance if I get EI benefits, even if I work with a lawyer? Does EI reduce severance? I think I did answer that, Luco. I said that, yes, EI can reduce your severance, but it reduces as it doesn't eliminate it. You still have significant entitlements. So yes, if you've been let go, if you're on a leave of absence, if you're not working, you're owed that severance. Yes, we can deal with DI. And sometimes, by the way, there's a way to structure the severance in a way that it doesn't even impact DI. But your employer is not going to pay you that severance on your own. Okay? So happy to chat with you anytime. All right, continuing here. We have some follow-up questions. Sir G has a follow-up. How would the suspension of the federal employee vaccination mandate impact the federally regulated industries that still have mandatory vaccination policies? Well, good luck to them. The reality is that in those industries, first of all, I say that even in those industries, if someone was let go without compensation because they're not vaccinated, that was a wrongful dismissal. But definitely now, if someone is let go now or not being brought back to work, that's definitely a wrongful dismissal. Of course, we're only talking non-union employees, but the fact that the federal government announced that they're getting rid of mandates makes it very difficult, even more difficult than it already was for federally regulated employers like banks, like telecommunications, trucking. Makes it very difficult, more difficult for them to justify their own mandates. Okay, so those employees whose job has been impacted have even better cases now in light of the federal government getting rid of those mandates. So excellent question, Sergi. And I've already been speaking with federally regulated employees across Canada, and my team and I are helping them. It's not even going to be difficult at this point. All right. I think I have another follow-up from Rocket. If my employer let me go without cause, do I have to train my replacement? Is it misconduct if I refuse? Well, presumably you mean you haven't been let go, because if you've been let go, it means you're not at work anymore. Potentially they said that they're going to be letting you go. yes, if they said they're going to be letting you go, generally speaking, if they want you to train someone, it's not illegal to do that. Okay, and you don't want to give them a reason to say your refusal is a misconduct, and now we're going to say that the termination is for cause. So I wouldn't refuse. Okay, I wouldn't refuse in that situation. I would train, but of course, presumably you don't mean that they've let you go already. If they've let you go, you don't work there. If you don't work there, you don't have to train anyone because you're not getting paid. You're not working. But presumably, I think you mean that you're still there. For those, by the way, that want to contact me, I'm going to answer more questions in a moment. But for those that want to contact me, and very, very, very easy to do. Couldn't be easier, in fact. All you do, you see it below me, you go to employmentlawyer.ca. Again, it's employmentlawyer.ca. My address is there. My phone number is there. My team's address and phone numbers are there. Everything you need to connect is right there. Easiest way to do it, just go to employmentlawyer.ca. Okay, let's see. Continue, guys. You still have some time. You've got at least 15 minutes here, so ask your questions and let's make sure that I don't miss you and that you get your answer. Next question then comes from Evelyn on Facebook. Evelyn says, I won in human rights court, but they said I still need a lawyer. I am no longer a union member. Are you taking cases that are 3/4 complete? I just need someone to present it properly. Well, we would need to connect, and I want to understand, because there is some opportunity to pursue matters in human rights if you are if you were a unionized employee. But I need to understand what happens. Obviously, you say that you won. You didn't win because the case is not over. So if you said that it needs to be presented properly, it means that there's going to be a hearing on your case. So you haven't won. But yeah, we may be able to represent you. Obviously, I need to know more about your case. I need to know what happened. I need to know what the union's involvement is. If there was a grievance, I need to know all that information before I can advise you, number one, if you have a case, and number two, if it's a case that we can help you with. So Evelyn, contact me through employmentlawyer.ca, and I'll be more than happy to talk to you. All right. Next question comes from Rob on Facebook. He has a long one. Let's see if I can get through it. I've been employed at the same company for 36 years. Our company has been taken over. They say that it will be finalized by the end of June. On Friday, I was sent employment group benefits package and was told I had to choose one by Monday, sign it, and send it back. I know not to sign anything without discussing it with the lawyer, but we haven't received our employment letter yet. I don't want to jeopardize any compensation that I may be entitled to by signing this benefit package. What should I do in the circumstances? If it's just a benefits package, I don't have any concern with you signing it, okay? If that's all it is. Again, I haven't seen it, so maybe it's more than that, okay? If it's just about benefits, do I want benefit package A or B? You can sign it. It's not a problem. If it's more than that, then I need to see it. So if you say that it's just benefits, no problem. If it's more than that, then I need to see it before you sign it. It's as simple as that. So happy to chat with you. And again, if you want to send it to me, you want to connect with me, employmentlawyer.ca is the way to do that. Sergi says, are you providing legal consultations only in Ontario, BC, or Alberta? Would you take a case outside of these provinces? No, unfortunately, we cannot take cases outside of Ontario, BC, or Alberta. We're only licensed to practice law in those provinces. We may be able to give you a referral to someone in a different province, depending on where you're at, but we can only practice in those 3 provinces, anywhere in those provinces, but only in those provinces. Now, while we wait for more questions, ask them, by the way, don't be bashful. While we wait for more questions, I want to tell you about another resource that you absolutely have to know about, and that is the Pocket Employment Lawyer. You can find it very easy, pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We have a number of tools there, but probably our most popular tool is our severance calculator. So when you go to pocketemploymentlawyer.ca, you'll see our severance calculator tool. That it does what the name says. It calculates your severance, and it tells you how much severance you're owed. If you lost your job, if you're worried about losing your job, if you think it's coming, and by the way, it's completely free. It's completely anonymous. You don't have to put in any contact information. You don't have to put in your name. You don't have to put in your email address. You don't have to put in the company's name. None of that. It's just there for your information. You answer 3 questions about the length of your employment, the type of job, and your age, and it's going to tell you if you're owed 6 months severance, 12 months severance, or anything else. Okay, you'll be surprised. You're probably owed a lot more than what you realize, and certainly a lot more than what you've been offered if you lost your job. You should have that information. You should be ready with it. Everyone should know that information. And by the way, if you know a friend, a relative, a neighbor that lost your job, tell them before they do anything, okay, to go to pocketemploymentlawyer.ca. Again, it's free and anonymous, so check it out, pocketemploymentlawyer.ca. All right, continue to ask questions, guys. More are coming. That's great. Next question from Janet. I worked at a big company where I was mistreated by my boss. She was rude to me all the time, embarrassing me intentionally in front of my colleagues, belittling me and giving me assignments without little or no explanation, for which I would spend the whole day digging, which caused me work stress and anxiety. After less than 3 months, I resigned because I couldn't handle it anymore. Can I sue them? Well, if you can prove that you were mistreated and harassed, etc., then that could be a constructive dismissal. So you would be able to take legal action for constructive dismissal. In other words, that by putting you in this situation and giving you no choice but to resign, it's as if they let you go. And if they let you go, they owe you severance. So you can't really take legal action for the mental anguish, but you can take legal action requesting or demanding severance. But again, you would have to prove what it is that she did. Remember, your former boss is not going to say, yes, I did it. You're going to have to prove it. So my question always is going to be, how do we prove it? Do we have emails? Do we have recordings? Do we have witnesses? Do we have something concrete to show that she was, say, harassing you, embarrassing you, etc.? If you can show that, it's a very, very easy case of constructive dismissal. But you have to show it, okay? If you have the ability to show what happened, let's talk. Connect with me directly and my team. Employmentlawyer.ca is the way to do that. So Janet, hopefully that answers the question. If you have a follow-up question, by all means, ask it as well. Next question comes to us from Archie on YouTube. Thank you for your answer. Is there a point during a medical leave where my employer is allowed to let me go? Would I still be able to get severance? So I'm just trying to refresh my memory. So Archie, I think I answered that, right? I told you that you're owed severance, and I told you that you can be let go if there's no job for you, right? So I think I've answered those questions. So next question comes to us from Sue on Facebook. Where I work, my boss has installed cameras. My question is that I found out there are speakers and he can listen to our conversation. Plus, as a customer, he has called others asking what is said when he can't hear the conversation. Is it legal? So no, you can't have your conversation with someone else recorded without your consent. He can videotape. He can also record a conversation that he is part of, but he cannot legally record your conversation without your consent. In fact, that could be a criminal offense. So that's not allowed. So you may want to tell him that. If it continues, you may want to have me tell him that, because guess what? He's going to listen to me, okay? But no, he's not allowed to record your audio when you're speaking to someone else without your consent. So tell him you're not consenting to that, and remind him that it's not legal. If there's any problems, again, let me know. You can connect with me, of course, through employmentlawyer.ca. Last 5 minutes or so. Again, my name is Lior Samfiru. I'm the employment lawyer with employmentlawyer.ca, and I'm answering your questions. So you still have those 5 minutes. Ask your questions. There's still like a few minutes. Don't walk away without getting answers, okay? So let's get those questions in right now. Evelyn, a follow-up. Evelyn said that she had a human rights case. I did win with extra evidence, but they said human rights doesn't deal with it. However, I refuse to sign a disclosure because, okay, way too much and we can deal with it here. As I said, feel free to contact me, Evelyn, and I'd be happy to take a look at your situation, again, through employmentlawyer.ca. Question from Barb on Facebook. If someone lies about why they left a former job, is that grounds for dismissal? Lie involves their ability to do core activities of their duties. So depending on the lie, it does depend. If they were let go because they couldn't do accounting work and they were hired for to do accounting job in a new place, and they're saying that they were let go because of something else. It could. The question is, how does that impact the new company, and is it a big lie? Is it a material lie? If it's a simple lie where that the person was let go because because there was a restructuring, and the person said that they were let go because the boss retired, it doesn't matter, right? So the question is, does it matter? Is it a big lie? Is it a small lie? It could be cause for dismissal in some situations if it's quote unquote a big lie. If the reason the new company hired the employee is because of what the employee said, and it turns out that was false, they lied deliberately, then yeah, absolutely, that could be cause for dismissal. So I would need to know exactly what the lie was, and also what the job was. All right. Next question. Guys, couple last minutes. Ask your questions, please. You still have those last few minutes. From Jay on Facebook. In the event that you were dismissed long ago with 0 severance, would the past employer still be required to pay the legislative minimum set by the province? I understand that anything beyond a few weeks would have been long gone. So no, there's a 2-year limitation period for all of that. So you can only get severance, whether it's your minimum, statutory minimum, or your full severance, 2-year limitation period. So if the termination happened more than 2 years ago, unfortunately, you cannot pursue it. That's why it's so important, if you lose your job, to do something about it, to get your advice now, to ensure that the time doesn't run away, and before you know it, you're out of time, okay? Time will pass. So don't let that happen. Every single week I speak with people who were let go long ago, and they only now realize that they have rights, and by now it's too late to pursue it. Don't let that happen to you. Don't let that happen to people you know, okay? If you're watching this, you understand that you have rights. You understand also that you can't sit on those rights. So let's connect as soon as possible. All right. Next question from Sir G. Can you still claim constructive dismissal due to vaccine status on unpaid leave if your employer calls you back? Yes, you absolutely can, because the constructive dismissal happened at the moment that you were put on a leave. So if you were put on a leave 8 months ago, you've already been constructively dismissed. So you can choose to treat it as a constructive dismissal effective 8 months ago. You don't have to go back in that situation. But here's what I'm going to say. If you've been called back to work, if you're considering whether to go back or not, or if it's a constructive dismissal or not, before you do anything, before you tell your employer, yes, I'm coming back, or no, I'm not, let's talk. Okay, we want to do this right. We need to have a personal consultation so I can understand your situation, what your employer is, the type of job that you have, if they gave you other options, for example, like testing, etc. So the devil's in the details, right? So we need to speak before you decide to do anything. Let's see. I mentioned, by the way, pocketemploymentlawyer.ca. Again, I remember pocketemploymentlawyer.ca. I told you that we have our severance calculator there, but we have some other tools there. We have a tool that allows you to find out if you've been constructively dismissed. We have a tool that allows you to find out if you're an employee or an independent contractor. So many people are misclassified as contractors, but they're really employees. So we have that tool. We have another tool to allow you to determine if you've been discriminated under human rights laws, or if your matter is considered a harassment matter, and other tools as well. It's free. All of it is free. It's like having your own lawyer with you at any time at pocketemploymentlawyer.ca. Last question of the day from Arthur on Facebook. If my employer terminates me for reasons that are not true, am I able to claim a wrongful dismissal or discrimination? Well, it's probably not discrimination, but yeah, if you're let go and your employer makes up reasons to try to avoid paying you severance, then yeah, of course, that's a wrongful dismissal and you're owed severance. Remember, as long as you get your full severance, the reason doesn't matter. Company doesn't have to have a good reason. They don't even have to give a reason as long as they pay your full severance. A wrongful dismissal is a situation where you're owed severance and your employer either hasn't paid it or hasn't paid enough, okay? In the vast majority of cases, when someone is let go, they're owed a lot more severance than what they've been offered, in 90% of cases. All right, that is the time that we have for today. Thank you very much. Some terrific questions today. I love getting those questions. I love answering those questions. Thank you for joining me. My name is Lior Samfiru. I'm the employment lawyer, one of the founding partners with Samfiru Tumarkin LLP. And again, we operate across Canada, especially Ontario, BC, and Alberta. You can reach me and my team through employmentlawyer.ca. Don't forget about pocketemploymentlawyer.ca. I'll see you next time, and we'll talk then. Thank you, guys. Take care.